Good morning, Ms. Sibison.
Good morning, Your Honor. Madam Chief Justice, may it please the Court, I'm Wendy Sibison. I represent John Bacigalupo. He was convicted with his co-defendant, Gary Carter, of shooting two people at the Club Caravan in Revere, and then 15 minutes later murdering a man at the Comfort Inn in Saugus, all in November 1996. At best, I'd suggest that the evidence against my client was anemic, and that's why the errors that I'm going to talk about today are so enormous. They would be enormous in any trial.
Are you going to talk about the Bruton first?
I am. The first scene in Revere, I just wanted to quickly review the weakness of the evidence with Your Honor's permission, or I'll skip over it. I do want to emphasize that. At the first scene in Revere, the only evidence against my client, the only admissible evidence, was the testimony of one of the victims that he was there and he shot both, that my client and Carter shot both of him and the other.
That's McConnell?
McConnell testified. There was no forensic evidence against my client and no incriminating statements made by my client.
You had said in your reply brief that there was no evidence that your client left in the town car.
That's true, Your Honor.
But how about the Taurus? Was the Taurus still found at the scene?
Yeah, that was Carter's car.
Right, but so you have somebody who McConnell identifies to be your client in the town car, and then
Leaving
Taurus
the town
is,
car.
Sorry?
And leaving the town car, getting out of it.
Okay, and then the Taurus is still there. So
Yes.
is the jury to infer that he called a cab or something? I mean, how else?
I think the jury would need to speculate on how he left. There could have been a third switch car left there. There are many reasons, many ways people escape from a crime. I think that would be a subject of speculation.
But there was no
Your Honor.
evidence of any third car, was there?
No evidence, no. No one, not one way or the other. No evidence how my client left. Only Carter.
So you're saying that the only evidence against your client, you say, was only as to the first shooting?
That was McConnell. That's right.
Yeah.
And the only evidence. And he was a cooperating agreement. He didn't even give this evidence until 4 years after the fact. No forensic evidence. No incriminating statements by my client. The second scene, the only evidence against my client was ballistics. He had to have been at the first scene because there were two guns used at the first scene and two guns at the second scene, and one of the guns in the first scene was used in the second scene. That's it. No forensic evidence against my client, no incriminating statements by my client. So just saying this was...
If I just get the thread here.
Yes.
So there's evidence in the first scene, and there's two guns used in the first and two guns used in the second.
Yes.
And one of them is the same.
Yes.
And so all that would show is that one of these two, Carter or the defendant, was at both places.
Yes, ma'am.
But that's just guessing as to which.
Yes, ma'am.
Is that your point?
That is a point. Yes, it is. Now, and also my point is, at best, it was really thin evidence against my client. So without getting into any of defense counsel's atrocious behavior, which is laid out in my brief, and I'm happy to discuss it later on, without getting into any of his negligence or his really outrageous treatment of this family and failure to investigate any of this crime, there are two big reasons.
Can I just back up one?
Yes.
None of the guns was recovered.
None. That's correct, Your
All
Honor.
right.
Two big reasons why all the convictions must be vacated. I've already had a couple of questions about the insufficient evidence that my client even ever got to the second scene. And the other one is Bruton.
Okay, let's focus on Bruton for a moment.
Yes, Your Honor.
If we only had the first statement that it was a friend,
Yes.
would you be arguing Bruton?
Excuse me?
If all you had was the first
Yes.
statement by Carter that
Yes.
there was a friend and I involved in that
In the first shooting. Yes.
would you be here? Or would you be here arguing that point?
Of course I would.
So you think the friend alone is sufficient, even though the evidence from McConnell is that there was somebody who plainly came up in a town car to help with the shooting?
Without the statement, Johnny shot Bobby in the
Yeah,
head?
without that,
Would I
without
still
that.
be here? Yes, I'd still be here saying there was a grave Bruton problem.
And why wouldn't Richardson answer that? Just taking what Justice Gant says.
I would say that a statement that, and here are the friend statements, I just kind of review them in my head. Carter felt that he was going to be killed by Moreno. He enlisted a friend to help him steal a car, to help him protect himself. A friend, while Carter and Moreno were in the parking lot, a friend came flying up in the stolen car. The friend then got out of the stolen car and started, then he was cut off. That statement directly incriminates my client because it says he was his Confederate. There were only two Confederates there. Only two Confederates at the shooting.
But how
But it's
would the jury supposed?
inferential. It's inferential.
Well,
I
it
mean,
is. I don't see that it's inferential that since there were only two Confederates involved in the shooting, Carter, who admitted he was one, and one other guy, and he says his friend arrived there, flying up in the hot box, jumped out of the car. There was no evidence anyone else did that.
Well, there were two guns used.
Yes, that's true.
And
But
there
if
there was clearly a second person.
yes, and if the jury heard nothing else, and this is the gray test, if the jury just heard what I said, and plus Carter's own statements against himself, which all came in, that he started shooting, the jury only heard all of that, they'd have no question who the friend was, the other guy sitting at counsel table, and that's the test of gray. So I guess the court's going to have to struggle with it a little bit about whether it's inferential. I think it's obvious that if you're saying if Carter is saying there was one other guy there helping me, my friend, he came with the stolen car that my friend helped me get, and he jumped out and he started.
So what you would say why Richardson why it doesn't control here is that Richardson says you get rid of the references and even the existence of the other person.
Well,
And
yes,
so you're saying-
or conversely, the way Gray distinguishes Richardson, if the jury would have no question who was being talked about without any other evidence, that settles it. And I think this passed that test.
It's very different than Gray. I mean, Gray, when you deleted, I mean, it
Well,
has-
deleted, and got to the point where the other guy actually did something. This didn't get to the point where shots were fired. I understand the distinction that Your Honors are going for. Nonetheless, I don't think it's an important distinction. By the test of Gray, the jury only heard this. They'd have no question who he was talking about, who was the friend. He was his Confederate, the other guy who did the shooting.
Now let's add the Johnny part or the John part.
Thank you, Your Honor.
Is there any consequence legally to the fact that that was brought in through the co-defendant's attorney's question as opposed to the prosecutor's question?
I provided this court today with a 16L letter about a case that came down a week ago in a very similar set of circumstances where a co-defendant's counsel brought up the client's right to silence. And this court held that under those circumstances, you're going to do the same analysis as if anybody else made a mistake, the prosecutor or the judge. And I think that case should be applied here. That reasoning certainly applies here. Now, what I wanted to make sure this court understands, this was not a fleeting, passing reference that might have escaped the jury's attention. I want to really emphasize this, because there are cases where something bad happens, and this court has held, well, defense counsel didn't object, it was a very fleeting reference, probably no harm. First, I want to talk about not a fleeting reference, and with the court's permission, I'm going to read how this came in. Co-defendant's counsel set this statement up very dramatically so that the jury would be listening. He asks John Patty, to whom Carter made the confession, now, Mr. Carter allegedly told you about the shooting of Mr. Noguera at the Comfort Inn. Is that correct, sir? He did. And you believed what he told you? Yes. And you reiterated that story that he told you in front of the grand jury under oath. Is that correct? Yes. And you believed everything you told the grand jury was true, right? Yes, the way I remembered it. Okay, sir, you told the grand jury that Johnny put his arm out the window, fired a bunch of shots at Bobby, and then put 2 more in his head, right? Yes. That's what you told the grand jury? That's what he told me. And that's what Gary Carter told you. Exactly. Then there's some wrangling about some objections by the prosecutor, something else, and then he goes on. Are you saying that Mr. Carter told you that he was there and he saw 2 bullets being shot into the head of Mr. Noguera? Affirmative. This was set up and it was really dramatic. Now, in case there's any question that defense counsel didn't think it was a big deal and that's why he didn't say anything.
Well, that's not what Judge Healy found.
Judge Healy found that he did notice it.
Well, there may have been reasons why he didn't raise it.
Well, I'd like to get the record clear on exactly what defense counsel testified to, if I may. And with the court's permission, I'd like to read you what he said. Question. Do you recall that during cross-examination, Mr. Clifford said in question to Mr. Patty, you told the grand jury that Johnny put his arm out the window, fired a bunch of shots at Bobby, and then put 2 more in his head, right? I remember that, yes. And you didn't object to that at the time. I did not. Do you recall that you bumped Mr. Bacigalupo? I think I grabbed John's knee and I said, do you believe that Charlie's bringing this up now? Because I thought we had an informal agreement ahead of trial that I wouldn't refer to Charlie's client and he wouldn't refer to mine. Charlie was adversely impacting John Bacigalupo at that time. I didn't like it, but I didn't object to it, and I already told you why. Well, clearly you thought this questioning was harmful, right? Absolutely, but you didn't object. And you didn't object because why? As a matter of trial strategy. Here's this trial strategy. I only thought it would bring it to the attention of the court. Me asking for a mistrial in front of Judge McDaniel? His famous words, denied all the time. And then if I asked for a curative instruction, which maybe I should have, it would only focus attention on John Bacigalupo. But the law at that point is curative instructions don't help anyhow. Motion for mistrial is the remedy, the only remedy for this kind of error.
Now, was there a motion to sever? There's some confusion in
There was a motion to sever, and Judge McDaniel ruled that the statement made by Carter was not in furtherance of a joint venture, so it should be redacted to, no references to Bacigalupo. He made all the right rulings in denying the motion to sever. Because, of course...
There was another motion during the first part of this also.
During the friend part.
Yes.
That's correct. And at that point, the judge, I think, is probably around that motion for mistrial when the friend stuff came in against the judge's orders. This was a witness that was a little out of control. He really wanted to get that friend stuff in. Judge kept wrangling with him, which, of course, only drew the jury's attention to it. And then the judge gave the instruction, this has nothing to do with John Bacigalupo. Well, this is the classic scene discussed in, I think it's in Bruton itself, where a curative instruction only tends to make the jury understand more that this stuff that they're arguing about is the defendant.
And during the motion to sever, was there any discussion with Mr. Clifford as to whether he intended to make reference to John?
No.
So there was no question asked of defense counsel of Mr. Clifford, do you plan to offer anything that may incriminate?
No, everything that Clifford was the one who said my co-defendant has a real Bruton problem. But when the judge made all the rulings...
Was Clifford or was it...
It was Clifford who said,
Clifford who raised the Bruton
Mr. McBride's client's got a real Bruton problem. But the judge then took care of it by his rulings. And there was no indication that Mr. Clifford wasn't going to abide by those rulings. And that's why McBride says, he went on and said that somewhere in his testimony that Clifford had violated the judge's rulings. He agreed. That was not good. But he didn't do a thing. And the main reason he gave was he didn't want to move for a mistrial because the judge was just going to deny it. Another reason he gave was I made that decision whether to stand up and object and potentially aggravate Charlie Clifford, a great trial lawyer, a very pugnacious lawyer, and create a larger rift between the two of us. Well, this isn't a good tactical reason either. So that's what happened with the Bruton error. The jury heard Johnny shot Bobby in the head. That is about as directly incriminating as any statement can be. It was chilling. It was horrible. There was no objection. And the judge then gave a joint venture instruction, joint statements of joint venturers, which said that once there's a joint venture, statements of all joint venturers can be used against each other without giving the jury any guidance on when a joint venture ends, or maybe the statement that they heard wasn't part of a joint venture. Didn't tell them any of that. So now the jury's going, hey, I heard the statement of a joint venturer, and it said, Johnny shot Bobby in the head.
Implicit in what you're saying is that in his final instructions, the judge did not repeat the instructions about the statements of
He did not.
Patty were
He did
only-
not, and no one asked him to. But no one objected, no one thought, wait a minute, this instruction is going to be a problem.
Now, going back to the joint venture instruction,
Yes, Your Honor.
were there any statements that arguably could have come in as part of a joint venture?
No. As far as
admission?
I know, maybe co-counsel will correct me, as far as I know, the only statement of anyone that came in, of either of these two defendants,
Was Patty's
was
statement.
Carter's confession to Patty. I'm pretty sure that's it.
Well, but that was before this happened. There were some other statements to Patty, but they were before the events of this. They were in October, I think.
Yes, they were setting up, trying to get a gun. That's correct, Your Honor. Yes. They were before there was any evidence that a joint venture had begun. But that's true. There were other statements. So anything else, Your Honor, would like to talk about the instruction? No. Because
No,
I'd love to have time.
Let's move a little bit to your claim of conflict. Here's my concern
Yes.
about the claim of conflict. I
Sure.
understand all the concerns you had about
Yes.
the representation.
Yes.
But what I'm concerned about is it your contention that if an attorney says, I will do this case for $20,000, period, I'll just take $20,000. If it costs more than that, I'll take the hit. If it costs less than that, I'll make some money, that is by itself a conflict of interest for an attorney because it would motivate the attorney to do less work?
Well, I think if the attorney discloses, I'm not going to spend any of this money on investigation. I'm not going to hire an investigator. I'm not going to spend any of my own time going out and talking to witnesses. I don't think I need to. I'm just going to take all the money. I think that's a problem.
Okay,
Because
but
all
I mean,
lawyers
but
need
you're
to do
but you're arguing
investigation.
conflict of interest in trying to, through that, trying to avoid any
Expenses.
need for prejudice. No, I mean, by arguing conflict as opposed to ineffective assistance of counsel, you get a different standard.
Yes.
And it seems to me that you're stuck with ineffective assistance of counsel and not with conflict of interest because every attorney at some level who gets a fixed fee could arguably be said to have a conflict because the less they spend, the more they keep. So by your theory, then we would have a conflict of interest in every fixed fee case.
Well, I'm not sure I want to spend a lot of time on this because my claim about Vincent Marino, I think, is my strongest claim, and that doesn't require the court to find a conflict because it is per se negligent to not interview any witnesses. I want to give one more thought
Okay, but
to
still,
how to answer Your Honor's
Going
question.
to Marino, let's put aside the Marino or Portallo, whoever he is.
Yeah.
You have the judge's findings pretty much saying this witness would be a complete...
Oh, let me respond to that.
Yeah.
May I? Okay.
Yes, of course.
The judge said, here's the way the law works. If the judge, and this court I think wrote about it pretty recently, if a judge finds that a lawyer made a decision for a reasonable tactical decision, then this court does not view the evidence that's kept out in the light most favorable to the defendant. But if a judge makes a finding, as the judge did in this case, that it was a tactical decision not to interview Marino, and that is absolutely belied by the record, and I'm happy to talk about that, and there is no good tactical reason for what happened here, then this court has to look at the evidence that didn't come in the light most favorable to the defendant. That's Roberio. And this court recently, somebody else tried to rely on Roberio recently, and this court made that exact distinction. So first, in order to get the standard I'm looking for, that you have to believe Marino and then decide if that would have helped my client, you need to decide whether the judge was right or not in saying, oh, it was reasonable tactical decision for McBride not to interview him. I want to tell you McBride's testimony was, I didn't interview any witnesses. I made the decision. I did not have to interview any witnesses. After the fact, and Kimmelman versus Morrison says no lawyer gets to make up a reason after the fact why they didn't interview a particular witness or didn't do a particular thing. No after the fact explanation. His real reason, and he was totally candid, I didn't have to interview any witnesses. I was all set. That's why he didn't bother to go interview a precipient witness and victim and the guy who was right there potentially going to contradict McConnell. So my position is there is no good tactical reason. Your Honors can read this. Your Honors can also read Marino's testimony. He was unimpeached. Prosecutor tried to impeach him. So the only thing he was impeached on was the implication that he's a nutcase. And he had a good reason for believing that, I know it sounds crazy, but believing that there was a device implanted in his body because the federal agents told him so. And I gave Your Honors affidavits saying that. So that could be dealt with a jury. On the one hand, you've got a guy, McConnell, testifying under a plea agreement, testifying for value. On the other hand, you've got the other guy who's right there saying, I got no reason to be here. Mike Bacigalupo wasn't even there. And given everything else, the thinness of the evidence here, my client deserves a new trial. This was a really bad trial. The Bruton error puts it way over the top, but there were other horrible things that happened. And I just don't, I guess that's all I have to say. I would ask that these convictions be reversed and judgment for acquittal be entered on the murder charge.
Thank you, Ms. Sivison.
Thank you.
Good morning. May it please the Court. Madam Chief Justice. My name is Macy Lee, and I represent the Commonwealth in this matter. I'm going to begin my argument with bringing to light to this Court the full reading of what John Patty testified to with regards to Bobby sticking his arm out the window and firing 2 shots into Bobby's head. I'm sorry, Johnny firing 2 shots. What the defendant failed to do in reading the transcript was to continue on, which reflects in a very clear light the context in which this statement was used in impeaching Patty. After he asked him, and this was a loose quote from Patty's testimony from the grand jury, that Johnny put his arm out of the window, fired a bunch of shots at Bobby, and then put 2 more in his head, right? Yes. That's what you told the grand jury. That's what he told me. And that's what Gary Carter told you. Exactly. And he was telling you the truth, and you believed him. Objection, Your Honor. The objection is sustained. He continues. Mr. Patty, can you explain, maybe for me, and this jury, why it is that the autopsy report shows that there is only 1 bullet in Mr. Noguera's head? Objection, sustained. Answer, I have no idea. Sustained, you don't have to answer. He goes on. If I were to suggest to you, sir, that Mr. Noguera did not have 2 bullets in his head, would that change your testimony? No. Are you saying that Mr. Carter told you that he was there and he saw 2 bullets being shot into the head of Mr. Noguera? Objection, sustained form asked again. During your conversation with Mr. Carter, did Mr. Carter, as you testified to the grand jury, tell you that he saw 2 shots being put into the head of Mr. Noguera? He didn't say it like that. That's how you said it to the grand jury, though, isn't it? No. It continues. In his closing argument, Mr. Clifford then says, in attacking the credibility of McConnell, Maley, Patty, he says, that Mr. Carter told you that when Mr. Noguera was on the ground, the man went over and shot 2 bullets in his head. Read the autopsy report, 1 bullet in his head. The purpose of this limited, loosely quoted statement by Mr. Patty before the grand jury was for the pure purpose of impeaching Patty's testimony, that Patty was a liar, that Carter was a liar, that really the statement had no substance whatsoever because there was not 2 shots shot into Mr. Noguera's head, but just 1.
But they've just heard him say that Bobby shot.
Right,
Whether
but he
2 or 1. So he's saying, well, it doesn't matter because no one would believe it. Is that
right? He's using it for the pure purpose of impeachment and saying that there.
Or doesn't it really matter that it was said?
It does. I think it's very important for the court to look at the context in which this statement was used. And it was used not to show that Johnny shot Bobby in the head. It was used to show that, well, okay, you said that Johnny shot Bobby in the head twice, but Bobby was only shot once in the head.
But there's a whole, I mean, there are lots of reasons why he may have shot Bobby twice and only one bullet went into his head.
Right, but that's absolutely correct. But for the purpose of what Mr. Clifford used the statement, which was for impeachment, it wasn't in any way to attempt to implicate the defendant in any way.
But it clearly did implicate him.
It did not, Your Honor. I submit to you it did not.
Your suggestion is that the statement was, the whole colloquy was to show that the witness couldn't be believed, period.
Period.
So
Whether it was Johnny, Bobby, 2 shots, 1 shot, we don't know.
Ms. Lee, I have read this. I didn't come away from this thinking, oh, it's just totally incredible testimony.
Well, I would submit to you that it was in using this particular statement and what Mr. Clifford used in his closing argument in attacking.
But Mr. Clifford is not representing Mr. Bacigalupo, right?
No, he represents Mr. Carter.
Yeah,
but
correct. So he's doing it for whatever reason. He's not focused on, is this going to implicate Mr. Bacigalupo? He doesn't want to have the testimony believed.
That's correct.
Because it implicates his client.
Right, that's correct. But it doesn't implicate Bacigalupo in any event because
No, it does.
I submit to you, Your Honor, that it doesn't. In the 7 days of testimony, this is the one testimony
But he just
that was
said
used.
he shot him. 2 bullets, there's 1 in the head, and I'm sitting on the jury and I'm thinking, you shoot 2 in the head, 1 misses, 1 goes, bang, bang.
And then Patty says, well, he didn't exactly say it that way. He then recants, and later on, in the same part of the testimony. So,
Yeah, but that whole theory depends upon the jury accepting the strategy to impeach. And they don't necessarily have to do that.
they don't, but the whole strategy of this case is that nobody saw anyone shoot anyone.
Yeah, but it sounds like a bad strategy. I mean, if you've got a case with a Bruton problem and you're reintroducing the Bruton problem into your strategy, that you don't have to use his name.
You're reintroducing the Bruton problem not as a problem for your client, but as a problem for his client. I don't care about his client. We've seen this 1,000 times.
But I submit to you, Your Honor, this one limited statement in the days of testimony and 160
But that's
pages.
a different claim.
But it does not in any way powerfully
But Ms. Lee,
implicates the defendant.
You're backing off fast. First you say, didn't implicate at all.
doesn't.
Didn't. Now you say it doesn't powerfully. It's just
Well,
a small piece. I mean, it's pretty powerful. It's pretty powerful. Now, it may be in the context that it just breezed past the jury. That's different.
Right. I would submit to the court that it was not in any way implicative of the defendant. Given the strategies of both defense attorneys, which is they focused their strategy on attacking the credibility on all the witnesses, the government's witnesses, their main strategy was that nobody saw anyone do anything. There was no forensic evidence. The strategies did not involve pitting both defendants against each
But
other.
apart from what the strategy was, why is it not reasonable for a jury to listen to that and say that Carter has just said that he was with Johnny at the time that Noguera was killed and that Johnny was the one who put the bullets in his head?
I think the jury, could listen to that testimony, but again, if they're going to place it in context of what the defendant's defense was, it was not in any way.
Defense. They don't believe the defense.
They didn't because of all the other overwhelming evidence in this case.
Maybe, but the strategy that every government witness is lying.
That was pretty much the defense for the most
Yeah,
part. That
not
Patty was a
not
liar.
a real good defense. So I'm the jury so I'm going to pick through and say, which pieces of these am I going to believe?
Attorney Lee, could I just switch the subject for a minute?
Yes.
What is the evidence in this case that connects Bacigalupo to the second shooting, to the fatal shooting?
There are, based on the evidence presented by Charles McConnell, the jury can make reasonable possible inferences that what had happened after the shooting at the Club Caravan in Revere, the two drove off in a dark-colored sedan, which is the testimony of not the security guard, one of the employees at the club, Barry Portnoy, who was...
2 people drove off?
Yes, they saw, the one employee said that after he heard gunshots. He ran to the front door of the club. I believe he was a bartender at the time. He saw a dark color sedan, either I believe he said a Cadillac or a Lincoln, driving off, speeding away.
He didn't see
testify
two
as to
people.
who was in it, though.
No, he didn't. No, he didn't.
So where does the evidence that you've just stated that there were two people who drove off?
Well, then there wasn't any direct evidence, but I believe based on the evidence that was
Or what's the
presented.
influential evidence?
What the inferences that could be made is that there's a testimony that the car left the scene. Then Barry Portnoy, right before that, saw two men. One he knew
from
one of them
behind
had,
it.
Yeah, he knew one had a gun. He wasn't sure about whether the second one had a gun, making shooting movements, ducking, moving back and forth, and ducking behind a dark-colored car. There was testimony to that effect.
Yes, so that's at the first shooting.
Right, and then, so all of this evidence concerning the first shooting then connects to Amy O'Hara's testimony, who was a police officer who responded to the scene at Revere. She testified that she grew up in the area and that at approximately 1 o'clock in the morning, it would take minutes to travel to Saugus, which is proven by the testimony of the Saugus police officers that they received
Yeah,
a
but how does
broadcast.
this implicate this defendant?
I'm sorry?
How does it implicate this defendant?
Again, Charlie McConnell says that he was shot by both Bacigalupo and Gary Carter.
You're saying it's a reasonable, once you have O'Connell getting him in, placing him in Saugus.
Yes.
Given the time frame and this other evidence of two shooters by other people, and the two guns in both places.
That's correct.
One of which is the same.
That's
that
correct.
the reasonable inference could be drawn that he is the second person in Revere.
That's correct.
But why isn't it? I mean, I'm having a little bit of a problem that the two people at the first shooting necessarily have to be the same two people at the second shooting.
Correct.
Well, I think based on the overwhelming ballistics evidence in this case, there could be a very reasonable and possible inference that the semi-automatic that was used to fire the projectile found in McConnell's car and the one found in Robert Nogueira's body obviously came from the same weapon. That was the testimony of the ballistician. We also know that a revolver was also used at both scenes. Nothing conclusive because of the lead, the softness of the lead of the projectiles and the fragments. The ballistician could not conclude that the same revolver was used. However, two guns were definitely used. The semi-automatic was certainly used at both scenes. And based on that, the jury could reasonably and possibly conclude that based on Charlie McConnell's testimony that he was shot at by both Bacigalupo and Carter, that they then jumped into the car, people saw the car speeding, and at approximately 1 o'clock, a little bit after 1 o'clock, they then murdered Robert Nogueira. And that is within all the time frame and all the pieces of puzzles that the various witnesses presented to the jury. This is the conclusion that they could reasonably and possibly make.
Is the evidence that they were at the club, the Caravan Club, what's the time that they...
The time, I couldn't find in the transcript the exact time of when the police officers responded. I looked through all the testimony.
Well, what are the outer limits?
I'm sorry?
What are the outer limits of the time?
The outer limits is, I know that they started out at Winthrop at approximately midnight, and they were driving around looking for Gary Carter, and they eventually found him. And that I believe there's testimony that from Charles McConnell that at approximately 1 o'clock they arrived at the club Caravan. There's no other testimony from any law enforcement officers as to when the call was placed, when it was received at the Wonderland Ballroom, when they responded to the club Caravan. But based on McConnell's testimony, it was approximately 1 a.m.
And what time was Revere?
That was Revere at 1 o'clock. Saugus was 1:25. That's when they received call. And in addition to that, Barry Portnoy, who was driving from Logan Airport and going home to New Hampshire, was driving right towards that rotary and passing that driver. He testified that it was approximately 1 a.m. in the morning when he passed by the scene and saw the two gentlemen in shooting-like motions.
And what did the police officers say was the drive time between the two cities?
Amy O'Hara, Officer O'Hara, testified that it is within minutes, and that's a direct quote. She didn't provide a specific minute, but she said it
In
could take...
Saugus and Reading?
Yes, from Revere to the Saugus. And the Comfort Inn.
Revere and Saugus and
You mean between the two specific scenes, crime
Yes.
scenes?
She said it would take within minutes at 1 o'clock, and apparently the Comfort
In
Inn...
minutes meaning 2 minutes?
It could mean 2 minutes, it could mean 5 minutes. She said within minutes.
And
There
the
was
actual
not-
time was approximately 25 minutes?
Yes. Yes, based on the testimonies of McConnell and Portnoy, and then the actual call that was received in Saugus was 1:25 a.m.
Okay. And was there evidence that Bobby Noguera was the enforcer for McConnell and Marino, or not?
There is testimony to that effect, yes, from Melly testified that he's an enforcer, and then also Patty testified that Carter was nervous and scared because he owed money to Portala, and the Portala had Noguera as an enforcer. Yes, there was testimony to that effect. At this point, I'm going to also address the issues concerning ineffective assistance of counsel, in particular calling Vincent Portala, also known as Vincent Marino, and also known as Gigi Portala, as a witness. The Commonwealth submits that it was sound tactical judgment on behalf of Attorney McBride for not calling Vincent Portala. The defendant says that the affidavits attached to her reply brief indicate that there was, I believe, a GPS device implanted in Portala. In fact, the 3 affidavits attached to the brief indicate otherwise.
Okay, but how can it be sound tactical advice if he didn't know anything about what Marino was going to say?
Well, again, John McBride testified at the motion for a new trial hearing that his primary defense was nobody saw his client do it. He didn't need to interview any witnesses. He also knew of Vincent Portala's reputation, knew that...
Do you know of any case in a murder one indictment where we have interviewed nobody?
No. I do not have a case for that proposition or for that holding.
Do you think it's extraordinary?
Not given who the witnesses are available in this case. I do not.
Anyway.
Given who the witnesses are, all of which are serving federal sentences for either credit card fraud or racketeering, I think it was sound tactical judgment on McBride's part not to interview and to not call these witnesses on his client's behalf. In fact, Judge Healy, who presided over the motion hearing and was able to observe the credibility and demeanor of Vincent Portala, found that he was hostile, he was arrogant, he was volatile. He used examples to prove his mental stability, such as his belief that a device was implanted in his body during his surgery after shooting at Mass General Hospital. He had a lawsuit for $25 million against the hospital.
About interviewing the shooting victim and recipient witness?
I don't believe there's any. His testimony is that he didn't feel the need to.
No, I know. He says he doesn't feel the need, but I mean, come on.
I think, again,
what are you going to make of Mr. Weinstein's affidavit?
Given his testimony at the motion hearing, he felt that it was sound tactical decision.
You can mouth those words.
Unless the court has any additional questions, the Commonwealth will rest on its brief.
Thank you, Ms.
Thank you.
We'll take a short break.
All right.